That's weird. I'm not seeing my face. Not seeing my face anywhere. Let me just toggle this first. Okay, and then this. Okay, here it is. And, okay, that's good. And let me just turn this on. All right. Okay, so let's start. Yes, good morning, everyone. Of course, to Mishore for that introduction, to my fellow speakers, and also, my friends in CDO Bytes and our guests and incubatees here in Zoom. So today I'll be speaking about data privacy in the context, of course, of startups. I'm going to cover pretty much what's mentioned, of course, in the law, the Data Privacy Act of 2012, specific to NPC Circular 16-01 and NPC Advisory 2017-1. Now, just to give you the gist about what we're going to talk about, we're really going to talk about the policies or the things that you all will need when you have that startup in place. Now we're also going to talk about how you guys are going to conduct this and make sure that you are complying with the law based, of course, on the IRR and of course, the obligations as well mentioned in the DPA of 2012. So really, these are the things that we have to take in mind when we talk about data privacy. We have to create privacy and data protection policies as actors in startups. Later on, I'll explain to you what your role may be, and how we're going to ensure that we're obliging and complying with this law, and how we're accountable. How we're accountable also with the law. Another thing is we also have to inform and cultivate awareness on privacy and data protection within the organization. Eventually, you are startups, but when everything goes well, when you're really, really big, you'll have to ensure that you cultivate this privacy awareness to your people. Either you're a controller or a processor, but later on I'll explain to you what those two things are, or those two roles are. And another is to conduct a mandatory agency-wide training, privacy and data protection policies, probably once a year, provided that a similar training shall be provided, of course, to all of your personal orientations. But really, what is Republic Act 10173? This law was created to protect the fundamental human right of privacy of communication while ensuring free flow of information to promote innovation and growth. As startup, that is where you are all focused on, right? We're trying to come up with new ideas, new services, new products. We're trying to innovate and we're trying to grow. Now, how can we ensure that we're protecting the privacy of people while we're doing this? This is why the law was created, and this is how we're going to learn or really know the basics of what we need to do to ensure that we're going back complying with the law. Next is to ensure that the personal information in information and communication systems in the government and in the private sector are secure.
Change my name kay it says ihatid. Change name, Rene.
Hi, Mamri. Okay, so let's go ahead and talk about, what this law is trying to achieve and what are we trying to do as eventually processors or controllers of or actors of the law. Well, what we're going to achieve, of course, and maintain is we will have to ensure that the implementation and rules and standards to respect privacy rights and to assure confidentiality, integrity, and availability of personal information. We have to ensure compliance, governance to lead, direct, and control data privacy assurance and security of personal information controller, and also enabling capability for personal information controller and processor to accomplish the mandated requirements of compliance that are monitored in order to assure privacy protection and information security. And of course, provision of regulation and procedures to create policies, to file complaints, to investigate violation, and to provide remediation. Okay, so if you take a look at it, it somehow tells us, A, wait, that's the work of the government. But no, that's going to be the work of a personal controller and also a personal processor. We have to ensure that we abide with the law. We have to ensure that this is implemented strongly in our organization to ensure that this law is well implemented nationwide. And as startups, we have to know it as early as now. Now, what does the law tell us in terms of what we need to eliminate? Well, of course, we need to eliminate violations against Data Privacy Act of data subjects. Okay, so there's another word there. We have the data subject earlier. We talked about, or I mentioned about controller and processors. So these are two actors plus the data subject. The data subject here is us. Okay, anyone you collect information from our data subject. So it can be me, it can be Miss Shore, Ma'am Maria, and everyone here in the room. Now, what else are we trying to eliminate? Nonconformity of the filing system, automation program, and technology services to the data privacy rights, data privacy principles, lawful processing criteria, condition to process sensitive information, and security measures in the personal data collection, processing, retention, sharing, and disposal. This is what the data process flow, right? We collect, we process. There's that retention there, sharing and disposal. In every step, we have to apply what we call the data privacy principles, which later on I will also have to discuss to you. And of course, we also need to eliminate insecure technology infrastructure and negative user behavior of unlawful access, control, processing, transmission, storage, sharing, and deletion of personal data. I believe someone else is going to talk about the violations or the punishable acts mentioned, of course, under Republic Act 10173. Now, to continue, there's a legal liability of data privacy compliance in all the three actors listed here. We have the controller, the processor, and of course, we have the data protection officer. What is a personal information controller? Usually these are business owners or the head of agencies in the government, the boss. No? And it's defined, of course, it's defined in the law as a natural juridical person or any other body who controls the processing of personal data. So the one controlling and the one who instructs another process personal data on its behalf. Okay. There is a control in the natural or juridical person or any other body decides on what information is collected. So this person is the one controlling the processing of the data. He's the one who decides how this is going to be processed. This is the person who instructs another organization or another body on how the information should be processed or the purpose or extent of its processing. So this is the person controlling us. Usually, again, going back, it's the business owner, it's the head of agency. No, it's the boss. What else does the personal information controller do? They implement reasonable and appropriate organizational. Okay, so they have to implement, going back, organizational, physical, technical security measures for the protection of personal data. The personal information controller takes steps to ensure that any natural person acting under their authority and who has access to personal data does not process them except upon their instructions or as required by law. So right now, probably as startups, what are you? Are you a business owner or are you going to, or do you have this service or this product that you're going to pitch to a client, and the client becomes your controller that time, you're going to be the processor. And that means that the processor has, not the processor, I'm sorry, the controller has to implement organizational, physical, technical security measures to ensure that there's protection to personal data. However, you can't just, as a processor, you cannot just, process them if you don't get their instruction. So that's pretty much the difference between a controller and a processor. But let me still further define the other actor. Okay, this responsibility of a PIP, that's actually a responsibility of a PIC. Sorry about that. But yes, as a controller, as a head of agency, we will have to ensure that we designate a data protection officer. This is one of the pillars. We actually have 5 pillars in order for us to comply with Republic Act 10173. And one of the pillars states that the head of agency should designate a data protection officer. Is it needed? I guess the question now is it needed? It depends, If you're a business and, there's only a few of you, or maybe there's a minimal risk there, no? There's really no need for a data protection officer, but you have to ensure that you have a compliance officer for privacy. It's the same, except that, um, uh, you might not comply with the others. Not that you're not going to comply. It's more on some of the requirements you may forego. You may forego, which I will explain later, just to make sure you get the understanding of that later on. The difference between a data protection officer and, of course, a compliance officer for privacy. What else is the responsibility of a PIC? Again, this is a responsibility of a PIC. PIP there is incorrect. The next thing is that this PIC, the head of agency, should also conduct a privacy impact assessment for each program, processor measure within the agency that involves personal data. Actually, this also even includes systems, projects. No? There should be a privacy impact assessment, and that's also part of the pillars. That's also part of the pillars. Now, in the law under NPC Advisory 17-01, it states there, it's part of the guidelines, that when there's a new system, so bago siya nga system, we will have to create a privacy impact assessment prior to its implementation. Okay, and that is a must. Now, if, say, for example, we have systems, we have processes that were already implemented prior to the law being commissioned, then we will have to have this privacy impact assessment done. But if you have any other new processes, new programs, new systems prior to implementation, it is a must that we conduct a privacy impact assessment. How do we do this? There is a template that we can all download under the website of NPC, privacy.gov.ph. They also have a toolkit where all of the forms, the templates, we can all download it from there. However, is it required that we really need to use their template? No, it doesn't. As long as we follow the guidelines mentioned in that advisory. No, I can probably send some of the resources to Ms. Shore after this session, so that, of course, our incubatees will see the document that I was talking about. Next is to also create a privacy and data protection policies. This is taking into the account the privacy impact assessment, as well as sections 25 to 29 of the IRR. So what this really talks about is that as startups, as PICs, as PIPs, we cannot create policies if we have not done the PIA. Okay, so prior to us doing any privacy policies, privacy notice, all of those stuff. Before we even do that, we are required to do the PIA. Okay, that is the flow of the guidelines mentioned in the advisory. Okay, what always comes first, going back, is the PIA. Now let's proceed. This is still under the PIC. To conduct mandatory agency-wide training on privacy and data protection policies once a year. Okay. To register. Okay. So if it's a system, this is to register data processing systems with the commission in cases where processing involves personal data of at least 1,000. So if it's less than that, there's really no need for you to register the system. But if you're assuming that it's going to reach more than 1,000, go ahead and register your data processing systems. Or if you're actually collecting sensitive personal information. Okay. So that's also another thing that you'll have to do to ensure that you comply with the law. And last, to cooperate, of course, with the NPC in the review of data privacy and security policies. So those are, by the way, the personal information controllers' responsibility. Now let's take a look at the processor side, see what they're responsible of. The processor, looking at the what do you call that? The smiley thing. Forgot what it's called. Anyway, it says it's any natural or juridical person or any other body to whom a personal information controller may outsource or instruct the processing of personal data pertaining to a data subject. Okay, so these are usually outsource companies. No, they just process the information. No, they have a different mission. The mission of the PIC differs with the mission of the PIP. Usually, it's part of their service, no, sa the PIP. Say for example, here's a good example. Say for example, Jollibee. Uh, I can't remember if there was a website. I think Jollibee had a website, no, but it has been decommissioned because they were vulnerable. They were vulnerable in terms of their collection and storage of their customers' data. So we do this via when we order food before COVID. When we order food, we call the 7,000 hashtag delivery, right? Now, when we call that number, we're routed to a call center. We all know that. The call center there is the PIP. No, that they're not Jollibee. They're a call center. Okay? And Jollibee said, okay, you call center, you collect the information. Once you have it, you give it to us so we can deliver the food. Okay? So in that case, Jollibee said, you call center. Jollibee there is the controller. Jollibee is instructing the call center, which is the PIP, to collect information, the only information that they need so that they can deliver the food that the data subject, the customers ordered. Okay. So the call center has a different mission. Their mission is to collect the information, ensure that they can collect a lot of calls, no? Because more calls, it actually means more money. That's how it is. And of course, send those orders to Jollibee so that Jollibee's mission is to deliver the food, ensure it's lami and all. So it differs in terms of mission. And the processor, going back, cannot just process any information without, again, the instruction of the PIC. Okay. So what else does the data data. Yeah, the personal information processor do. They perform the instruction to process personal information, of course, based on the processing agreement with the PIC that protects privacy of data subject. Privacy protection measures taken to ensure privacy. And the measures include data protection and limitation on gathering, combining, and processing of data and individuals. Okay, so let's proceed. The date. Okay, I thought I have more, but I haven't. But anyway, personal information processors implements reasonable and appropriate organizational, physical, and technical security measures for the protection of personal data. That's the same thing I said in the personal information controller. Now, it doesn't mean that because you are the one processing, you were just instructed by the PIC. It does not mean that we are not obliged, again, to implement organizational, physical, and technical security measures in protecting the information that we collect. So, meaning to say, as PIPs, no, whether we're a PIP, we will have to still be obliged in terms of the security measures mentioned in Republic Act 10173. Okay. Now, as a service provider engaged, okay, that's not part of it, but if ever we work with the government, for the purpose, or as a service provider engaged by government for the purpose of storing personal data under the agency's control and custody, functions as a personal information processor and complies with all the requirements of acts, its IRR, and all applicable issuance by the commission. So what it tells us, again, going back, is that we will all have to still follow what's written in the required IRR written in the DPA of 2012. Can you just give me a few seconds? Just a few seconds, please. Sorry. All right. I think I'm back. Okay. Yes. Sorry about that. My throat got dry. Okay. So anyway, let's go ahead and proceed. Let's talk about the other actor. The other actor is the data protection officer. And the reason why we're highlighting this person is going to help. No, this person is going to help the organization comply with the Republic Act 10173. Okay. Now I want to be clear on this. When you are the head of agency, if you take a look at the things that I mentioned, when you are the head of agency, it doesn't mean that the data protection officer is going to do all of the things. No, it doesn't mean that the data privacy protection officer is going to do the PIA. Remember, it says that the PIC will conduct the PIA. So prior to the data protection officer, no, writing their policies, no, recommending policies, best practices in the standards, before that data protection even gives out his recommendation, the PIC should initiate the conduct of that privacy impact assessment. Okay. Okay. Because a good example of this was the Comelec issue. No, Commissioner Bautista was saying, "Why are you, uh, what you call this, blaming me? I'm not the developers of that system." He said that in the interview. Okay, and then he was told that there's that Republic Act 10173. There was a recommendation of your data protection officer to uh, to do a vulnerable assessment, to do this and to do that, but you did not follow. So there's a recommendation from the DPO. However, the head of agency didn't do anything about it. No, and then here comes the Comelec, and you know, as a head of agency who doesn't probably understand what the law was about, he was saying, "You blame the developers. You don't blame me. I'm not the one who created the system." But again, you are, as a PIC or a PIP, you are also responsible in securing the personal data of your data subjects. Now, the data protection officer, going back, is designated by the PIC or the PIP. You're also accountable for the organization's compliance with applicable laws and regulations for the protection of data privacy and security. A very good tip for DPOs, if we have DPOs in this room, is that when you're giving out recommendation, ensure that it's all well documented, just in case there are violations, then safe ka. No? Now, why are we talking about data privacy? Why are we all here? There is actually a basic belief of data privacy protection. First is that it is a human right. Next, it is because PICs and PIPs are obligated to protect personal data. What else? System owners and developers are obligated to conform to privacy and security rules and standards. No, personal data has to be secured also against security threats that violate the confidentiality and integrity of personal information. So as PIPs, we are accountable and responsible to secure personal information. Now, a very good thing to think of this time, especially when we're out there in the malls, no? You see the logbooks, you see QR codes there. Every time people would scan, every time people will write down their information, they always have that thinking, di ka ni kawato ng akong ngalan, akong phone number. No? That is also probably why some people would put in fake names, would put in fake what you call this, phone numbers, because going back, there is no trust in terms of the security of their data. Okay, so to ensure that there is trust, no, we will have to ensure that we comply with the law. We take care of their information, whatever we do as PIPs and PIPs. Why? Going back, because there is a basic belief of data privacy protection. All right. DPA, the law aims to protect the fundamental human right of privacy of communication while ensuring the free flow of information to promote innovation and growth. As actors in the DPA, what do we need to take care of? We need to take care of personal data, personal information. And this is defined as any information from which the identity of an individual is apparent or can reasonably and directly ascertain, or when put together with other information would directly and certainly identify an individual. Now, you might wonder, okay, that's a PI. All right, that's fine. Now, why are we highlighting this here? Very good. I want to get answers. Say I'm going to tell you, you know what? There's this person who stole 1 million from me. These are the data. Okay, who do you think is that person? Male, 75 years old, holds a government position, popular, currently Metro Manila, original from Davao. Who is this? Let's go ahead and check the chat and see if I can get some answers from you guys. Miss Shore said earlier, let's participate. Okay, so let's see. Who is this person? Okay, very good. So somebody said it is, yes, it is the president of the Philippines. Okay, this is what the personal information is all about, really. But really, what this talks about is that in the Data Privacy Act, you know, we have to take care of personal information because with little bits of details, without even saying the name of the person, no, with little bit of details, we can definitely ascertain an individual as long as we connect the dots. And that's also the reason why the OH is only giving us a few information in terms of Kinsay positive here in Cagayan de Oro, say for example in CDO. No, what do they give out? The age and the location. Kung asa nga barangay. But no other. Ang atop sa balay pula. Or kung nag-eskwela ni graduate ani. Okay? So they don't give that information. They only give out limited information so that we cannot ascertain an individual. Because if we are able to ascertain an individual, what happens? As human beings, we judge, we discriminate. Okay? That's how we are naturally, no? And this law actually helps with that social concern in terms of discrimination. And that's pretty much really also one of the reasons why the law was created. Okay, now let's proceed. Now we talked about the personal data, the personal information, and now the question is: so how would we know if we're lawfully processing information as PICs or as PIPs? How would we know if we're processing the information lawfully? Okay, these are the criteria. First is that we have to get the consent of the data subject. Did the data subject give us consent that we can process his or her information? Next, uh, next is if it is in the form of a contract, meaning to say there is really a need for us to do a contract to fulfill a service. Of course, we need to process information, right? So that's also lawful. There's a need for us to go into a contract. Next, the processing is also necessary for compliance with legal obligation. Okay. Uh, there are organizations that are mandated to process information. So, meaning to say, if the data subject, I have I have privacy rights, I can object to that. No, no. Sometimes that's the problem. Some of the data subjects do not understand that if it's mandated by law, the organization is mandated by law to process the information without their consent, the organization can definitely process the information. Another, few examples of that is insurance commissions, no, ICs, uh, AMLA, those organizations, no, they can process your information without actually even you knowing it, no. Why? Well, that is lawful. It's a legal obligation. It's part of their mandate. Okay, so there are actually exceptions to the law. Okay, What else is listed there? The processing is also necessary to protect vitally important interests, life and health. What else? Processing is necessary in order to respond to emergency, to comply with public or safety, or to fulfill functions of public. I just got a pop-up that my internet is not stable. But let's talk about emergency. When we ride a bus, we're asked to go to the bus and show our ID. Some what their names in a logbook, no. So those are also part of. And of course, we have the processing is necessary for purposes of legitimate interest, lawfulness, fairness, and transparency pursued by, of course, PIC or a third party, etc. So that. Okay. So early on, we talked about personal information. We also are going to talk about sensitive personal information. What are these? These are just examples of sensitive personal information. Can be race, ethnic, origin, marital status, age, color. Okay, these are sensitive because people can actually use this against you, especially if they are biased about certain things. No, so that's why, as much as possible, if you're keeping or if you're going to collect and keep information, uh, ensure that the sensitive information are also well secured. Okay. Now let's talk about the obligations of, not the obligations, your obligations under the privacy principle. So there are actually 3 privacy principles stated in Republic Act 10173. We have transparency, legitimate purpose, and proportionality. Then let's explain this individually. When we talk about transparency, we actually talk about our data subjects, ensuring that they are aware of the nature, the purpose, and the extent of the processing of or her personal data. Usually we do this through a privacy notice. No, we inform them through that. We have to be transparent. It's available in the website, or if it's in the form, you can see it in a form, paper form, online form, whatever that is. Okay, the next is, of course, legitimate purpose. When we talk about legitimate purpose, when we collect the information that's stated, of course, in whatever system you have there, you use their information for the purpose stated in, let's say, in an online form. Say, for example, you're collecting their names, their email address, and their phone number so that they can be reminded to join a webinar. Say, for example, it's like that, to join a webinar. No, now that is legitimate purpose. You're going to contact them via text, via email, and you also got their name so that you can address them properly. So the purpose there, the reason why you're getting those information is so that they can be reminded that they have a webinar that they need to join. Now, of course, you have those 3 information. If you're going to use the phone number because you're going to sell a life insurance to them, so originally you ask for the information so that they can join a webinar, an educational webinar. Okay na to. Okay, that's legitimate purpose. But you used their phone number because you are also, by the way, what do you call that? An advisor for insurance. So you use the phone number, contacted them, and say, "Hey, sir, ma'am, I'm selling a life insurance. Are you interested?" Okay, now that is not legitimate. It's not legitimate use. Okay, so that's how we're going to define legitimate purpose. Or that's not how we're going to define it. That's how it is defined. Okay, so we only use the information that is required when we collected the information. And of course, we have here proportionality. And proportionality here really means that you just have to collect the necessary information that you need in order for you to, of course, perform your service or whatever that is. So meaning to say, if somebody's gonna join your webinar, no, you don't ask for their marital status. That is inadequate already. No, that's too much information you're asking them. Okay, so as PICs and PIPs, when we're going to collect information, we have to oblige under the privacy principles, transparency, legitimate purpose, and of course proportionality. Okay. Aside from obliging with the privacy principles, we also have to oblige and uphold the data subject rights. We actually have 8 listed in there in the slide. We have, of course, information. So data subject has the right to information, meaning to say they should be informed before the collection, the retention, the processing, the disclosure, and disposal of personal data in the event that there is a breach of the in the event there is breach of data privacy. Okay, so going back, how do we do this? How do we inform them? It's the privacy notice. It can be the terms and conditions, your privacy policy. Okay, that's how you're going to inform them. Next, data subjects also have the right to object, meaning to say if you have 2 check boxes in your system or in that paper, whatever that is, the first checkbox says I agree to the terms, and the next checkbox says what do you call this, we will contact you for direct marketing, etc. Okay, but before doing a checkbox, it's a not a radio button, it's ticked already. Let's just say it's the 2 buttons are already ticked. Okay, they cannot untick 2 of the buttons. Okay, no, that's not allowed. It has to be a checkbox, and the data subject should have the right to uncheck. And of course, if 2 of the boxes are unchecked, how can you provide your service? Okay, so meaning to say, the data subject just said, okay, I'm not interested with everything. I'm just gonna not join or whatever. Okay, so you need to ensure that in your systems there is that option for your data subject to untick that direct marketing purposes there. Okay, because I'm pretty sure the reason why they even are in your service or that system is because they're interested. So of course they will definitely check the I allow privacy, the terms and conditions. Pretty sure they're going to check that. But for the direct marketing, ensure that that's unclickable as well. Next, access. Data subject should also have the right to access. This actually means that what do you call this? Wherever they are, they can access it. It's the right to know whether data concerning him or her are being processed. They have the right to access information of them if it's really in your system. No. We also have the right to correct. The right to correct here is, of course, if there's anything inaccurate with their personal data, you should, as a PIC, correct them. Of course, the right to erase, right to damages, data portability, and also file a complaint. I'll just jump over to right to erase. I've actually done this with Stay Safe. When Stay Safe was just started, no, when they started last first quarter, I think. I signed up for Stay Safe. Now, after signing up, I went over their terms and condition in their privacy policy, and I wasn't really sure if they were following the what do you call this, the IRR of our RA 10173. So I emailed. Okay, so there's one thing. There should be a contact information, no, in your systems or whatever services there is. I emailed the email they have there, like their support email, and asked them to remove my information. So they routed me to another email address who's the one keeping the data, and they erased it. Okay, so I was a little impressed that they can actually do that, because a few years back when you ask somebody to erase, they won't even reply to you. Okay, so with the law commissioned 2012, they commissioned when came back on 2016, we will have to ensure that this is properly complied with. We also have right to damages. There's I forgot there's a Facebook post regarding this, where a certain client of a bank got 50,000 from that bank, because the personnel of this bank was using his or her information. I forgot what it is, but as data subjects, it they have right to damages. They can actually file uh, for damages incurred by, of course, the PIC or PIP. Data portability there, it's pretty much, it means that if you're, say, for example, in the US, you can access your data from anywhere. It can be through an application maybe, or a website, different uh, platforms. Can be in paper or soft copy, whatever that is. But you have to ensure that when you talk about data portability, there is a secured IT environment in that case, since, of course, the example I gave you was, say, for example, if you're outside the Philippines. And of course, file a complaint. The data subject can always file a complaint. And the next thing is the obligation to implement security measures. So earlier I mentioned this, no? PIC, PIP. We talked about the organizational, the technical, and physical security measures. What are these really? Physical, when we talk about physical security measures, these are actually your office space layout. It can be locks, physical locks. It can be the policies, really, the procedures implemented, of course, to monitor and limit activities in the workplace. So, as startups, if you're still in the paper and pen, although I'm not sure if you're still in that, you guys are tech startups. So, um, or if you print, this is just an example. If you print something and it has personal data, diba? Physically, you have to take care of that paper. Put it somewhere where nobody can get access to it. Put it somewhere that if a fire, if there's a fire, you can still retrieve the information, whatever that is. Part of the risk management. Technical. This is more on the aspect of security. So it's the password, encryption, firewall, anti-malware, security solutions. And let's also talk about the organizational. This is more on the systems environment, the individuals carrying out the security measures, really, privacy manual, access control policies, employee training. So those are things that you'll have to, of course, implement um, as PICs and PIPs. Okay. Of course, we were talking about in the context of startups, no, tech startups, I believe, but the Data Privacy Act is not really just about uh, online data. It can actually also be physical data. And when we talk about processing data, these are really the cycle that happens. No, there's that collection, there's the retention, there's the use, the sharing, and of course the disposal. In order for us to really comply with Republic Act 10173, we will have to see that number 1 to number 12, we will really have to, learn and read a lot about the privacy and security policies. No, it's not about complying really. It's more on being accountable because your data subjects will really trust you in terms of you keeping their personal data. No? Okay. Let me just. And then we have here, it's actually the same thing that I showed you earlier. But if you take a look at that, it talks about the privacy principles. Now, what obligations are there in each of the step when we're processing the information? No? What are the rights of our data subjects? So those are just a few things. I thought I was going to end up at 9:30, but I think I'm going to end up really fast because this is really my last slide. At the end of the day, our goal is to ensure safety and security of personal data. So as incubatees, as startups, we will have to ensure that we have a DOSAN who can help us with a ransomware attack. But really, we need to ensure that our data is safe and secure. Right? That's it for me. If you have any questions, feel free to what's our role here in this webinar? Chat, is it? Or unmute? Good morning and
Hi, Miss Maki. Thank you, ma'am, for that. I will be facilitating the question and answer, ma'am, so no worries. Can you hear me, ma'am? Okay. Okay, guys, the virtual floor is now open for questions. Okay, who would like to go first?
Pwede ko mangutana.
Okay, go ahead, please.
How many questions am I allowed to ask?
It's okay. Okay, as Miss Maki said, her lecture is supposed to be 9:30, and we are supposed to ask questions until 9:55, but it's still 9:08. So yes, you can have as much questions as you can.
Let's maximize the time. No, no worries.
Okay, so your first question ko is what if sa case namin sa Iatid we started the app and we didn't really we weren't ano about privacy policy when we started out, and once we got into naka ano mi contract mi og law firm, and then gi-advise me niya about it, then we implemented it. But clearly there were users na naggamit na sa among app who did not consent to any privacy policy statement. So now when they updated if they updated the app kanang and signed up, upon sign up they will ano be required to agree to it para makasulod sila. But they're not required to update or ano. Well, they can still use the app even if it's outdated, and they can still ordering platform and amo. What do we do about these data subjects? How do we get them to uh, we don't really kanang know how to get back to them on this. So
all right. So that's a really good question, no? And I appreciate that question because it seems like circuit here is trying to be accountable with this Data Privacy Act. So of course, we have to consider how the law. It's actually the same with the law, no? The law started 2012, commissioned on 2016. Prior to that, there were processes, there were projects, programs implemented. We just need to make sure that we what do you call that? Implement. Go back to these people. In your case, we go back to these people. If you have information from them, like an email address, maybe you can send them an email stating that you have an updated, or if you have, I'm sorry, you have a privacy policy, and there's that checkbox right there at the bottom part. So at least by then, you know that you are actually you complied because you send them that email stating that you have a privacy policy and this is to ensure that you're complying with with RA 10173. So you can actually send them an email. It's lawful because you're actually informing them. That's part of RA 10173. So if you're going to use their email, but you did not say, I'm going to use your email to send you updates because I never had that before. But if you look at the law, it is still lawful because it's mandated. There's legal processing there. It's mandated by the law. So you can actually communicate to them if you have their email addresses or whatever information you have them that you can communicate to them, inform them about your privacy policy. Also get their consent.
That's great. What about the device for acquiring their consent? Because I'm not a tech guy and I don't have the ano here. We don't have the our tech person here. So since it's email, we don't. Parang do they reply that I agree or is that required? There has to be parang a feature on that email that they have to click to to signify that they agree, that we can parang use as a put in our data, parang put in our archives na they've already agreed to that. Because my the way I see it, I think we have to implement something in the app na lang na they when they use it, it will be prompted on their app and they have to read it and parang agree in order to proceed, parang ganun. But since we don't have that, I just opted with emails, but we obviously we didn't get any response, so we don't really know what they think about it. So
Okay, I see. Okay, if that is the case, sir, I suggest that on your next update on your app, you include that.
okay, sige. Okay,
Yes.
got.
Oh.
So dili pa man noon kayo anak ka daghan pero medyo ubay-ubay pod
Ah,
ang
okay. Well,
user.
good to know that, ubay-ubay ang gagamit sa imo ang app. Congrats sa CDO Bytes. Sir, congrats.
Oh. Napa ko'y other questions pero basig na yung mga questions ang uban pod. I don't want to monopolize the floor here.
Sure, sure.
Okay, you want to have it later, Kit? Yung iba?
Yes, it's okay.
Okay.
Maura maning pinaka-important na ako karon. There
I see. Okay. Okay. So the virtual floor is now again open for other questions from the rest of our incubatees.
Can I just add something? I forgot this. I was talking
Yes, ma'am. Go ahead.
I was talking about it on the slide. And I talked about the PIA, the Privacy Impact Assessment. And the PIA, going back, it's by the PIC and the PIP. But when you see in the PIA that the risks are minimal, no? So wala kayo SPI siguro na inyong ginagamit, or gamay ra gyud kaayo ang risk if ever na I breach, there is no need to formalize that document, no? But there should be a recommendation by the data protection officer whether, going back, whether the PIA is needed or not. Okay, initially, when you even do a PIA, you would really already know sa man ang risk ani sa ako ang negosyo, no? Naaba ko yung mga SPI. Will there be any possibilities nga ma-breach ko and then there's an identity theft? Dako ba ang unsa ni siya, ang risk? If dako kaayo ang risk, there is a need to do an official PIA, well documented, approved by your PIC. Okay, because the PIA, it's not really the PIC who actually does the PIA. The PIC can create committees, no, can be 2 or 3, to conduct that PIA. And then this PIA, dili ni siya basta-basta lang nga all of your employees will be involved. Those who know, who are experts of the system, no, the processes, sila jud mismo ang inyuhang what you can do a survey, an interview, an FGD. That's one way for you to really to accurately understand whether there is a risk in your services or products, whatever that is, the system. Okay, and the DPO there will guide you, but the DPO, as much as possible, will not be involved in the actual conduct of the PIA. Kay mabias na siya. But of course, the results of the PIA, the DPO will then look at this document and okay. DPO then says, okay, high risk. Okay, let's give this document to the PIC. Okay, so if the PIC, okay, let's implement policies. Okay, DPO writes the policies already with the help of the process owners and all. So medyo taas-taas no ang what do you call this in terms of the process of ensuring compliance. Sorry. There's
That's
in that.
okay, ma'am. Okay.
Pero that's the part of the PIA. It's the reason why I'm highlighting the PIA is, you know, before you even do the implementation of the systems, before you even create the policies, that's the very first thing that we will have to create, the PIA, before doing anything else.
Okay, that is all noted, Miss Maki. Okay, does any of you any question regarding the data privacy impact assessment? Okay,
Question lang
go
ko.
ahead.
Was that the one that you mentioned earlier, na template or yeah. Okay, so we can have that template and then do an assessment.
Yes.
Thank you.
Oo.
Ms. Maki, in relation to the impact assessment, is there a need for our startups to have record keeping in all their data processing activities?
Yes, that's also included.
Okay. So, how do you suggest them to do so? Do they need to appoint or a data protection officer for that?
Not really a data protection officer. Okay. Good question. No? I like that question. In the law, it tells us that we have to appoint a data protection officer. But overall, a data protection officer is really somebody who's highly expert on privacy and security measures, the ISOs, no, the international standards. There's actually a lot, like 3100, 2700, 29001, and there's a lot. Okay, now for startups, what I suggest is you have your own compliance officer for privacy. This person has to read, going back, the IRR. Now, especially if you guys are going to partner up with government agencies, if naatay mga startups nga possibly will partner with government agencies. We have developers who partnered with government agencies, and there's a different IRR in terms of sharing agreement. No, government kasi when they use your system, a lot of them somehow would share this information to a different agency. Say, for example, the ICT. The ICT we're keeping information, and DTI is also asking for that information. So we can't just like give them the information immediately, but because there's a need for us to do a data sharing agreement. For your systems, if another company, another organization is going to access or wants to it wants to get access, no, they're not going to use the information, gusto lang sila makakita, then there should be a need to do a data sharing agreement as well. And that's a good question. Going back, there is, since startup pa man, not a DPO but a COP. Your COP should read the IRR and the advisories and the memorandums. That way you can ensure that you are all updated with the NPC guidelines. Because every now and then NPC is, changing some of course, the advisory, but not the ARR. The advisories, they're also giving out journals, which would really help, of course, startups, because they have journals for startups, for software developers, system developers. May mga ganun sila. There's a community also. We hope to have that here in Region 10. There are communities in the Luzon area. I'm not sure in Visayas, but in the Luzon area, where different DPOs or even COPs actually brainstorm and they create a journal so that other organizations are somehow following the best practices. But we cannot always create those just by thinking. It's always based on an ISO, just like the Republic Act 10173. So whenever we're going to do policies policies or rules, no, we have to know the normative references that will help us in terms of privacy and security. I actually can, or I think Ma'am Ria has the link, but yes, I can share to you the links for this fire session. I'll give it to Miss Sure so that she can get access to that, and probably create a online library for your incubatees, so that the next incubatees can also read through this, because it's really important that we have a strong security champions in terms of privacy and security in Region 10, especially in CDO.
Okay, thank you, Ms. Maki. So, incubatees, I hope that is clear. Any clarification with regards to that? Oh, okay. We have here a send question through private message, Ms. Maki. I think it is related to data sharing. Okay, I'll read it for you. Uh, Ms. Maki, does data privacy extend to third parties in scenario for a client as information such as customer orders and other details that are not part nor specified in its contract of partnership with a startup?
Can you repeat the question?
Okay. Okay. Uh, does data privacy extend to third parties in scenario where a client asks information such as customer orders and other details that are not part or nor specified in the data privacy contract of partnership with the startup?
Oh, okay. So I just want to understand, the client here is an organization, right? It's like, it's not a customer, I think.
Yes,
If
it
it's a
is.
customer, of course.
Organization. It's an
Yes,
organization or an
Oh,
establishment.
so
okay. Okay. If that's the case, there is a need to do a data sharing agreement. There is a need to do a data sharing agreement if there's a third party involved. Uh, if I can share the slide earlier, I'm gonna share it. It's this one, sharing. Okay. Number 5, data sharing agreement. When there is what you call it, if it's part of the data processing flow that you will need to share information, say for customer ID, information and other details to a third party, no, there is a need to do a data sharing agreement. You have to inform, though, the data subject that you are sharing this information to that third party. That's included in the guidelines of data sharing. Prior to you sharing the information, you have to inform the data subject that you're going to share this to this third party. I think I did not understand the part where you mentioned about the partnership agreement. So you mean the contract does not state any sharing prior to this? If that is the case, you will have to, I mean, that's already a breach of the contract, no? But you can always go back to this data sharing agreement. Say, for example, the contract already included data sharing agreement, but you did not inform the data subject. Say, for example, it's a data subject. So the data subject has to be informed that the information is or will be shared. If the question earlier, I'm really having a hard time understanding the question. Earlier, states that, oh, what's the question earlier?
I think
Mamaki,
Miss Maki, I
I'll
think you got it
expound on
right.
it. Hi, Urchil. I'll expound. So it's actually a real life scenario of one of our startups. I don't know if they'll be sharing this later on, but we took the initiative to ask it ahead. So there's a collaboration between this establishment and their startup. So they have a contract, but the establishment is asking for data that's not that's not exactly specified in the contract and are sensitive information which pertains to the customers details as well as to um, information that this about the startup that they're not supposed to share. So does that extend to the customers as well, the data privacy?
Ah, okay. Oh, well, let's go back to the contract. If the establishment is asking for other information and it's not stated in that contract, the startup should not be giving that information to the establishment, no? Because it's not part of the contract. But going back in this scenario, it looks like that the PIC is the establishment while the startup is the PIP. Now, my question here now is, why was the contract, why did the sensitive information, why was it not stipulated in the contract? The question is, who created the contract? Is it the PIP or the PIC? Because in this case, it should be the PIC who created the contract so that issues like this will not, uh, uh, you know, will not happen pretty much. But that's like my question mark there. Because if the establishment is the PIC, meaning to say they're the one who is controlling the information that the startup is collecting, then they should get access to that sensitive information. But if you look at the contract in terms of legality, if the SPIs are not included in terms of sharing this information to the PIC, let's just say that this contract is not created by the PIC, there's a problem there already. The PIC should have created that contract in the first place. In terms of, I'm not really familiar with this, Mishra. I think you're more familiar with the, you know, what do you call that? Kanang wala na ibisa ang contract, you go to a different contract. I think it's better that they do that. But
Okay.
mm,
Okay. Actually, even kami, we are not we don't know the exact details good kasi naghimo sa
oo.
contract and everything. But at least you were able to answer it, no? At least they know now that they're actually the ones who's supposed to be in control when it comes to data privacy sa contract because their startups are the one who know kung unsay dapat na i-share na information of daily, no?
Yes.
At least na-enlighten sila about ana.
Mm-mm. So that's a really good scenario, and thanks so much for asking that. But yes, when you have a system and you're going to let someone use your system, it's very important that there are what you call that, restrictions, limitations stipulated in the contract. But before you even do that, it's very important that you know your role. Who are you in the contract? Are you the PIC or the PIP? Okay. Now, if you are just processing the information, then you are the PIP. No? Your goal is to just make sure that the information is stored, collected, no? but you're not going to use it to provide service because your service is storing the information, processing the information through your application, through your system. The PIC is the one doing what? Let's say for the example, the Jollibee example I showed you earlier. I mentioned earlier, no? So before you even create a contract, know your role. Are you a PIC or a PIP? Okay? And then make sure it's really documented in your data sharing agreement, or not even the contract itself, not the data sharing agreement, because the sharing agreement is really more on there's another party involved, so tulo na mo. It can be another PIC or another PIP, no? But usually it's a PIC. But it can be another, so tulo na mo, it can be another organization, and that other organization is just, viewing the information that you processed as a PIP or as a PIC. So that's an example. I'm thinking of another example. Say for example here, there's this software developer, no? They developed a COVID app. This app, they sold this to, actually not, I'm not sure if they sold, but I think they sold it to an LGU in Caraga. Okay, so the governor. Now, in that LGU, of course, we know there are different mayors or different LGUs. Okay, so na ay mga municipalities. So there should be a data sharing agreement where all those municipalities who would want to get access to the governors, so the PIC there is the governor, the main PIC. The other PICs are what you call this, the municipalities. The PIP is the software development software developer. Okay? Now there should be one data sharing agreement. In that data sharing agreement, the governor is telling the PIP, the developer, that this municipality can get information from your system, but they can only get information that's under their jurisdiction. So if it's somebody outside from their jurisdiction, they cannot get access to it. But us as a PIC, us as Region Caraga, I can, there's no governor in the region, no? So in the province of, let's say, province of Agusan del Norte, I can go ahead and look at all of their information under their jurisdictions because I own the system. You're just the one processing the information, and I'm just going to share it to the municipalities so that they would know kinsay mga nisulod sa amuang jurisdiction nga mga positive para matrack pud nila. So that's the data sharing agreement there per se. Pero kung duha lang jud mo, you don't need a data sharing agreement. You just need a contract. Okay? Stop.
Thank you, Miss Maki. Okay, Miss Maki, of course, we do understand that prevention is better than cure, no? But however, if ever man na do you have any reminders or uh, clue how should startups address or say professionally handle in the case na may mangyaring breach in contract in the future?
Oh, okay. Well, not really sure in terms of that, no. Uh I can talk about I can talk about the RA 1173, but in terms of the contract, not written correctly, and there's a need for us to like stop. I'm not really sure how that is. But if it's stated in the contract, diba, there's that effectivity thing there, or there's like somewhere in the contract it tells us that we can terminate the contract. If there's a way for that startup to terminate the contract based on the contract, then go ahead and let them terminate the contract and redo the contract again. And they have to follow what's in the IRR of Republic Act 10173. Actually, it's all there, how they're going to write the contracts if they're going to work with organizations or PIPs. Now, I'm looking at this, as startups, as PIPs. That's how I look at it as of the moment, because what I'm looking at is startups are creating systems so that they can process data. And pretty much they will be looking for businesses who's going to, of course, buy their systems, for example. So the establishments there would be the PIC. Now, if the PIC has a contract, if the PIC is the one who created the contract, you as a PIP, you have to ensure, since you're the one who is being outsourced, you have to ensure that the contract is again obliged ka nang is following the guidelines stated in the IRR. So what I suggest, my advice to our startups, go ahead and open up Republic Act 10173, the IRR. No, read through 17-01 advisory. I'm going to give you the link so that you can go ahead and read through it. Even the PIA 16-01 also. Those are, you will actually see what you call this, how you're going to write down your contracts. Nakastipulate talaga siya sa IRR. For sharing agreement, dapat may ganito. For outsourcing contracts, dapat may ganyan. Dapat nakastate yung ganito. We have to ensure that we read them, no? So para if ever may contract na si PIC sa atin, we know what we need to correct, no? Para dili ta diretso mag-sign kay, us knowing the law is better than of course better than not. But that is my advice. That's my advice.
Yes, ma'am, that will do. I think importante lang na ang mga lang is for startups, of course, to have an idea and to be prepared just in case may tabo na sa ila. Okay, we have here another question sent via chat. Okay, Miss Maki, I will read it for you. Based on your observation, Miss Maki, what are obvious mistakes or violations of data privacy that startups make that they are not aware of? If there aren't any so far, what practices that adhere to data privacy do you recommend that startups should observe?
All right, very good. Okay. So, let's go back. Well, in terms of my observations, no. Not sure if I'm really an observant person. One of the startups I can remember is the Be Free, but it's like a hardware kasi sa kanila. So there's not really much of collecting information. But I'm going to look at this in terms of the COVID apps that are coming out right now. Ang dami talaga. Even the QR codes, for example, QR code systems that will help in COVID tracing. Well, so far there's that privacy policy. We have the terms and conditions. Those are okay. Okay, those are really a good start. What else? We also see the checkbox. The checkbox nga, I agree. I do not agree. Okay, so those are good things. But the question now is, before you even implemented the apps or the system, did you do a privacy impact assessment? That's my first question. Okay. Now, I am not sure kasi that's not something you have to inform in public. But if NPC would need that you submit the PIA, you will have to really submit the PIA. So that's one thing. Ensure you have a PIA. I think the others are okay, the privacy policies and etc. But what I would like to highlight is the obligations under the privacy principles. Okay, when we look at the privacy principles, we're looking at what do you call this? Proportionality. We're looking at transparency. We're looking at legitimate purpose. Are these being followed by the startups? Okay, those are the basic things that we need to apply when we're uh, doing that in our own own groups. Next is the security measures. Okay, the security measures in terms of technical, organizational, and physical. Yun lang sa PIA, the obligations for the privacy principles, and the obligations for security measures. As long as you follow those, you're good to go. Because the privacy principles, it actually covers the privacy notice na rin. Okay? And maybe you want to add another one, to uphold the data subject's rights. Okay? Ito na lang i-complete. Sige. Uphold the data subject's rights. So again, PIA, obligation of the privacy principles, uphold the data subject's rights, and the last is the obligations under the security measures, technical, organizational, and physical. Only those. You just need to remember those. Okay? Read the IRR. Maswito na kaana. That's my advice to them.
Okay, thank you, Miss Maki. We have another question in the chat box. Miss Maki, in the case now of booking platforms that are asking for basic information like names, address, and contact numbers, should the booking platform advise to have the data privacy notification or disclaimer?
Yes, there should be. There should be always a privacy notification.
Hi, ma'am. Good morning. This is RG from Dirtbag. So, as a PIP, ma'am, as a PIP, we're handling data. Then, we're trying to partner with establishment to become also a provider for us. So we will be sharing information to them. So my question is, for the privacy law, is it what's the focus of privacy law? Is it to protect the owner of the data, or also it also protect us from our PIC becoming our competition? So when we share data, they have a potential to become a competition to our business. So does the privacy law also protect us from that?
Okay. That's actually a very good question. No? The law's aim is to protect the human rights of privacy. Now, in terms of your question where you will have to share data to a different organization, which will also be eventually a provider, the question you ask is, this is just to ensure that I understand your question. No? They might be a competition because we're going to share the information to them. Okay, so that's your question. My question is, di ba meron tayong this is for the Miss Shore and maybe Mamri, yung sa copyright or IP.
Yes, ma'am, meron.
I think you are covered there in that part. So that means, so in terms of the Data Privacy Act, okay, you're safe in terms of privacy, but in terms of your competition or that other provider becoming another competition, you should be protected with the IP regulations, if I'm not mistaken. I'm sure. They cannot copy whatever you have, no, so that they can create another version of you, another version of your system. That's how copyright is going to help you.
Yeah. I think that in addition to what Ma'am Maki just said, that applies once you registered, you have your product patented or copyrighted. So unless you do that, you are open to several risks.
Okay. So it's not technically a cup. I mean, they that what you call this. So we will be trying to hire their drivers, right? So we will be sharing the data of the customers So they will be involved in the distribution of goods. So it's not really on a copyright. So the they may just use the data without
Ah,
doing the same thing. Just the data. They will what you call it. They will be stealing the customers because they will have the phone numbers and the address.
okay. That okay, now I understand. Okay. If that is the case, what you need to do is that you have to have a different type of contract with those drivers or what the establishment or organizer. I mean provider. The contract is called non-disclosure agreement, no? They cannot use whatever information you give to them. So it's not really a sharing agreement that you need to give them, but a non-disclosure agreement. Them being not really PIPs. They're not PIPs. They're working for you. You need to give them the information so that they can what you call this? Do the task really, but not so that they can store or even collect, no? It's just that for them to do the task. And if that is the case, a non-disclosure agreement is needed. Now, if they are owned by a different provider, then you will have to create a different contract in that case. So actually, daghan mo papel. Say for example, in the call center kasi, actually, the reason why we have this law is because of the BPOs. FYI to everyone here. The reason why we have this law is because of the DPO. This is not the Data Privacy Act that was commissioned or that was created on 2012 was based on a law that started last 1998. And that was because of BPOs, no? Now let me explain to you why I'm saying this now. Ganito kasi yan. Sa BPO, may PIC, may PIP. Yung mga call center agents are not PIPs. They are just employees working for the PIP. Okay? And these call center agents also will see information, names, email address, phone number, SSS, no? How can the PIP ensure that they're not going to use this information? A non-disclosure agreement is needed to be signed to these people para dili nila magamit ang katong information. Any breach to that, of course, pwede sila makasuhan or ma-terminate sa work. So I think that's what you need to do, sir.
Thank you, ma'am. That's very clear now.
Okay. Sige.
Thank you, sir. Okay. We've heard enough from Ihati, Dirtbag, Peace to Hand Sanitizer. How about the others? Do we have any question from Shift Tech Marine? Ken?
None so far, ma'am.
Okay, so, and then how about Ed from Checkmate?
No, ma'am.
Okay lang, napakoy pahabol, late na jud ka.
Hi, Shortcut.
Okay, with regards ni sa retention of data and should I say termination? No, because we noticed no that there are some users na they may have deleted the app and they reinstall it again and then their data is still there and when they log in, they can still log in. So what's the parang you said there that in your example you actively sought for the removal of your data from their application, but in our case wala na may nag-request ana and of course we do that if ano, but should there be a parang should that be a passive feature that automatically deletes their ano as soon as they uninstall? So what's the ano there, because that my issue here is we have their emails and we have their phone numbers and we have automated messaging that we text them updates and push notifications ganon. And that's what we intend to actually we did not use it pa because we didn't feel safe using it. So but it's our app is now capable of doing that, to automate emails and text messages and push notifications. But we are concerned now, not only those na kanang wala pa nakasign sa privacy, but those that have already deleted but still their emails are in um our app still, and there was no indication they already changed their mind with our except that they deleted the app. So um still they would have in a assuming na tapos na nag-sign up na sila, and then now we have the data privacy. So technically every if I implement these marketing approaches to them, they've already agreed to it because they signed the agreement, and unless they opt out of it, then we will continue to use that. But yun, what about those na delete and they didn't give us any so is there any should we hesitate, or what can we do about those clients?
Okay. Okay. So that's also one of the difficult questions for today. But anyway, sir. Well, yes, let's talk about retention. No? Ideally, we need to inform our data subjects that we're going to store their information at this certain time. That should be included in the privacy notice. Okay, ideally. There are, of course, going back, um, what do you call this? Companies, or not really companies, but government agencies. Let me just expound this lang. Government agencies that are mandated by law to store it forever. Example is the NSO. No, they can store that information forever. Uh, Now, in your case, ideally there should have been like information to the data subjects that if you delete the app, we're going to remove your information from our database. Okay. This is the same way Stay Safe is also doing it. In their privacy policy, it states there that after you delete the app, or if you don't want to use the app, after 6 months, we're going to remove your information. Okay. They have that. So they're transparent about it. Now your question is, we didn't have this information, and we have clients who already used our app and they deleted it. So how can we inform them? I think that's one of the question. How can we inform them that since they deleted it, let's remove their information? Oh, what else? What else? I think that's that's question, if I'm not mistaken. But anyway, my question is probably, how would you know that they deleted the app? So if you know that, okay, going back, there's no other way for you to inform them that you're going to remove their information. If you have plans to removing their information, of course, which you actually have to, because they're not going to use your app anymore. The only way for you to communicate with them is, of course, via email. Send them an email, okay, that you're going to remove them from your database. Now, if you don't put it in the email, if you don't hear from them, you will automatically remove them from the database within this certain time. I mean, after this certain time. That's what you can do. No? So, at least technically, you're not liable in case moingon sila, sure good ko nga kani siguro to nga app no mo nang sikog kadawat og mga marketing email sa lain-lain nga mga companies kay nag-sign up jud ko ani nga app, no? So at least you're informing them nga oy wala na mo ni gi-share. Actually amo gali ni siyang i-delete because we notice nga imo na siyang gi-remove. So that's one way for you to inform your data subjects, because there's really no way for you to inform them. Not unless, of course, I think there's also that certain, what do you call that? Process nga. If ilang i-reinstall ang app, how should the information be tagged in your system? Parang ganun rin. Although that's something also technical and I cannot answer that. But in terms of, how I expounded your question earlier, that's one way for you to inform them. You deleted the app. Your information is still here. We're going to remove this now. If you would want, just reply to us. If you're not going to reply within a month, then we will automatically remove it from our system. That you can do.
Sige ma'am, kay we wouldn't want to annoy them with our ads, and that's not our intention naman. And I'm glad na we can set a period pala, like a 6 months, not immediately, because we also don't want to annoy them once they return na ano oy kanang uninstall lang gali, nag-change phone ko, and now that pagbalik na ako wala na. So sige, salamat kayo.
Okay, no problem.
Thank you, Kit. Mom, we have another. This is a follow-up question. The one I've asked a while ago about yung sa booking platform ng data privacy notification disclaimer. How about daw, Mom, ang booking platform is through text? Is this still applicable?
Booking platform is through text. Okay. Okay, that's a good question, no? So Data Privacy Act actually is applicable whether it's offline, online, whatever type of communication it is, no? As long as there's personal information involved, in the process of delivering that service, we have to comply with the law. Now, in this case, if it's via text, no, how can we get that privacy notification? Okay, so that's the next question. Going back, we have the right to access, right to data portability. We have to ensure that the PIC, the owner of this business, if they're doing this through text, they are somehow accessible in any other types of medium where we can, the data subject can ensure that they can access their privacy notification or disclaimer there. No? That's another thing. We have to go back with the privacy principles, the rights of the data subjects, and the security measures. Okay. So PICs, they're really required to comply with it, to oblige themselves with the three things that I mentioned. So kahit naka-text siya, going back, the privacy notification should still be accessible, and it should also be accessible, and the data subject should still be informed of which. Best practices, since it's done through text, include in the text that if you want to know your data privacy, or if you want to ensure that your rights to data privacy is, say for example, is uphold, visit our Facebook page, search this, something like that. No need really for a link in the text box, but ensure that the data subject is informed that they can view the data privacy notification somewhere else. Yun lang po.
Okay, thank you so much, Miss Maki. Again, thank you, Jude Ma'am, for a very technical, detail-oriented, and informative session. Okay, let's now head on to our group photo, since it's 10 a.m. and our next speaker is here.
Thank you so much for that, Miss Maki. Okay, so group photo, everyone. Would like to ask our second speaker, Miss Heva, to please turn on her camera as well. Okay.
Ha.
Okay.
Wait
Group
lang.
photo muna tayo, okay?
Morning.
Alright, good morning. Alright, so Ed, will you be able to join Kit? May camera ba kayo?
Sorry, wala ko camera sa computer mo.
Okay. Sige. On my cue, on three. Right, smile, everyone. 1, 2, 3. All right. Thank you so much. Okay, that's the end of Miss Maki's talk on on some of the aspects of data privacy. Thank you so much, Mamaki. Thank you. All right. So now let's head on to the next part of our session. So the next part of our virtual fire session is a talk by Ms. Heva Salik, who works as an information officer at the Regional Office of the Commission of Human Rights. She is also currently an associate professor at the Philippine Public Safety College Regional Training Center. With her professional background, we've invited her to help you gain awareness on why data privacy is a human right and what are the consequences if you violate it, because ignorance of the law excuses no one. So this is a short talk, all right, but it's still important. So in order to apply what you've learned about data privacy from Miss Maki's talk earlier, this part of the session will help you get to know the human right or the act better as well. So without further ado, I'll be handing the mic now to our second guest speaker, Miss Heva Sali.
Unmute. Clear ang audio?
Yes, clear.
Okay. Dili ako Good morning. Actually, very brief, as in short ra siguro ako ang part, probably because I've attended Miss Makabuat's discussion on data privacy, which is very siya din yung nag-provide sa amin ng Data Privacy Act on the technicalities of the law itself, with bago lang mga last month with teachers. So mag-focus na lang ako sa mga rights that is involved in the Data Privacy Act, since I think yun naman ang rason kaya I'm part of this session, no? If you've seen the law or the Data Privacy Act of 2012, rights-based po talaga siya. In fact, most of the things that it allows or disallows, may katabi o may may corresponding right involved, no? Miss Maki, I think, has mentioned of b.i.t.e.s, yung mga nag-handle ng information or nag-hold ng information, mga data subjects, etc. I have a bit of familiarity on the topic kasi though not specifically designated in the Commission on Human Rights, I am more or less in charge of handling mga information on our participants, on our kapag may mga activities tayo. So if we would use the technical term as provided by the law, ako yung data protection officer, no? So I know the weight that kumbaga dala-dala kapag ikaw yung nag-handle ng information, no? So before you start anything, hindi naka-record o nag-record. So nag-record kayo ngayon, supposedly before you do anything and nag-record ka, nabigay mo yung privacy policy nyo, no? These are things that are hindi na-follow or sometimes nakakalimutan. Kaya minsan it opens a lot of legal implications. So for example, nag-start itong Zoom meeting na to, it should have been set as a ground that we are recording and verbal consent of your participants na umuo sila na i-record yung etong session na to, no? Or at least in our part, ganito ang palagi namin pinapakita. Wait lang ha. Yung ganyan. Okay? So at least dapat minimum compliance na to, no? Meron ka bang privacy notice? Kung i-record mo to, meron ka bang privacy notice? Kung magpapa-picture ka na group picture, you cannot actually set as a directive na pwede pong pa-open ng mga camera nyo, no? Dapat it should have been if you may allow or ganyan. So these are little things on data privacy na hindi natin napapansin, especially in avenues like this, mga uh, trainings, webinars, and sessions, no? So ano ba ang implications nito kapag hindi mo yun ginawa? Well, you are opening yourself to a lot of uh, um, infractions on the Data Privacy Act, no? Kasi number one, right that I guess should be mentioned is the right to be informed. So, ipapa-change mo yung mga names ng nag-attend ng webinars mo, or in this case, for example, your apps, no? Kailangan full name, etc. Ganun naman talaga lahat ng apps. Little do people know, humihingi ng names, humihingi ng ganyan, without any, hindi ka nagsiset ng ground, ng level na, ano ba, para saan ba itong information na to? How will this information be stored? It's very important. If you will see, tingnan niyo ulit po yung aming privacy notice. Kasi itong privacy notice namin, idinaan po namin ito sa National Privacy Commission. In fact, the data privacy seminar conducted with the Commission on Human Rights last year was conducted by the National Privacy Commission, no? Your information, asa na ba ito, shall be subject to reproduction, correction, and or deletion upon your personal request. This, all in all, ito lang ang privacy notice na to, nandito na lahat ng rights ng isang data subject, no? Rest assured that your data shall only be used for documentation purposes. So, sabi nga ni Ma'am Maki kanina, the basic reason why this law was created kasi dahil sa mga BPOs. If you've noticed, I don't know if you've tried, mag-try ka mag-apply ng credit card online or even personally via phone, etc. Once your credit card line becomes approved, hindi niyo napapansin, pinapadalhan kayo ng iba-ibang banks ng credit card, or sometimes different companies, banks tatawag sa'yo if you would like to avail. Kasi we found out that meron silang tinatawag na parang community, no? Na those that have good standing, those that are pasa-pasa. In a very personal experience, nag-apply kami, ang Commission on Human Rights applied for a MaxiCare health insurance. Okay lang naman siguro i-share yun, no? Chinek ko kung may mga data, may mga implications ang pag-share ko. So, the Commission on Human Rights applied for a MaxiCare health insurance coverage. Tapos, ang nangyari nito, probably after 6 months, we were bombarded by a lot of calls from a specific health insurance company, local here in Cagayan de Oro. I forgot the name. Nakalimutan ko yung pangalan. And then, hindi na ako, for example, hindi na ako sumasagot ng tawag niya kasi nga may existing na kami na MaxiCare Health Insurance. So what they did is they contacted the number of my husband. So, sinabi nila na ganito, etc., etc. Ang fault nung agent na yon is that she shared, tinanong kasi namin kung paano nyo po nakuha yung personal data or information ng husband ko. For example, they had his name, his full name, his number, etc., etc., email, no? Sabi niya, kasi po ma'am, nakuha po namin sa MaxiCare. So, yung agent namin, tinawagan namin siya to remind her of the implications of sharing our personal data to other healthcare insurance companies, because that's against the law, no? I think Ms. Maki has shared that may mga penalties ang pag-share ng mga private information. So similarly with you po, if ever your apps or your applications would store data, you would have to inform your data subjects on for what reason you are storing their information, and you have to stick to that reason. Hindi mo pwedeng idahilan na, ay kasi may community po kami na we have list of good standing. Yun yung dinahilan sa amin ng healthcare company na yun, na kasi ma'am, maganda po yung standing mo, etc., etc. Kahit na number 1 ka pa sa standing na yan, even if you are number 1, you do not have the authority to transfer or give to other healthcare agencies yung personal information that was given to you. So we looked into the data privacy policy ng MaxiCare, ang nakalagay doon is storage of your personal information is for their purposes only. So sino ngayon ang nag-violate ng Data Privacy Act, no? If we had pursued that, in fact, ang agent namin pwede actually siya maging liable under the Data Privacy Act. And as mentioned earlier by Mamaki, I assume na di po ba may mga penalties both on fees and fines ang ating Data Privacy Act. So please stick to the basic rule that whatever kind of information you are gathering from your data subjects in behalf of your applications, etc., ini-inform mo para sa kanila. Ini-inform mo sila kung anong reason yon. Why? That's security for you and that's security for them. Okay? In the event na lumabas yung information nila at tinurong ikaw ang nagbigay, you merely have to prove that you stuck with the conditions provided in your privacy policy at talagang hindi mo binigay yung information, no? In fact, what I do understand is storage of information has a length of time, no? For example, in the government sa amin, for the last 5 years, hindi na dapat namin sinustore yung information na yon. So that is fino-forward na dapat namin yun sa National Archives of the Philippines, so like the attendance sheets, etc., etc. And then you have the right to access, no? Kahit na ibinigay mo na yung impormasyon sa data gatherer or sa data protection officer, you still have the right to access that information. So for example, ano na naman ba ang mga personal example na pwede natin, gusto mong i-update ang PhilHealth information mo, no, yung MDR mo, so you will have the right to access what information they have on you para ma-edit mo, no? Hindi porket tinurn over mo na yung information na yon is hindi ka na pwede mag tanong o mag ano kung para saan ba itong information na to, saan nila inilalagay, etc., etc. If that certain company or agency is in the practice of disposing your personal information for a number of years, parang kami, anything beyond 5 years, hindi mo na mahingi sa amin kasi dinidispose namin yon or tinaturn over namin sa National Archives of the Philippines, at least you would know that they no longer have your information since na-dispose na nga nila yon. So yun yung tinatawag natin na the right to access. And then meron din tayong the right to object, no? Even since you have the right to access of the kind of information that you turn over to the certain agency, tapos makikita mo doon mali ang information na nakastore, you also have the right to object to that kind of information stored, no? Please remember, your information is yours. Hindi porket ibinigay mo na yon sa data collector or sa data protection officer, they do not have any right for any, hindi nila pwede i-edit yon, hindi nila pwede palitan yon, etc., etc. And if the data owner or the data subject feels or sees that the information stored about them is wrong, so pwede nilang objectan yon. Kasi kanila yun eh. In fact, it is merely being transferred to you. Kumbaga, safekeeper ka lang ng information. Pero ang the truth of the information lies with the data subject itself, no? So pwede niyang palitan yon. And then the right to erasure or blocking. So in case, for example, nagbigay ako ng mga information, nag-apply ako ng credit card, etc., etc. Umabot ako sa part na nag-submit na ako ng mga, ano ba mga sinasubmit sa credit card? ITRs, Certificate of Employments, valid IDs. Then, in the middle of filing, I choose not to go through with the application. Then I may call on the company that invited me to avail of their services na since hindi naman po ako magpo-pursue ng application or magkukuha ng kahit na anong services ninyo, may I reserve my right or pwede ko po bang hingiin na you no longer have the authority to store information about me. So hihingiin mo na i-delete nila or i-remove na nila sa kanilang database system or database rather, ang iyong information, no? That's also part of your right. So they cannot, in fact, that company cannot claim that the information is now theirs kasi nga tinurn over mo. As I have said, they are merely keepers of data or keepers of information, but they do not have ownership of the information that you shared to them. And then you also, like any kind of law, meron ka ding right to damages. So in case that the information has caused damage to you, katulad ng sinabi ko sa inyo na paulit-ulit tinatawagan ng mga healthcare companies, paulit-ulit tinatawagan ng mga banks, no? That alone, answering a call and then asking for 3 minutes of your time has already subjected you to a lot of disturbance. Na kunwari nagmi-meeting ka, tumatawag, etc. So you can actually claim that because of such information that you turned over to that company, na pinasa nila sa iba, it has cost you, for example, may mga na yung mga personal information mo napasa-pasa. It's common nowadays, like for example, I don't know the veracity of the truth of the matter, pero ilagay, sabi daw nila sa GSIS, if you, I don't know, this is just, I don't know if it's a true story or it's just a myth, pero I've heard of people who've actually experienced it. Sa GSIS daw, if you do not, kung hindi mo daw ginagalaw ang GSIS mo, for example, for 5 years in the government service, hindi ka nakapag-apply ng loan or whatsoever. So you, and then you only find, bigla mo na lang malalaman that there's a loan under your name, tapos hindi ikaw ang kumuha nun. So there's also a legal implication to that with GSIS and the person who took out a loan in your behalf, no? Bakit? Number one, hindi ka makaka-apply ng loan kung hindi ka magpo-provide ng mga personal information. And then second, hindi rin naman papasok yung loan mo kung hindi kinonfirm ng GSIS yung private information na yon. Okay? So, silang dalawa are actually violators of the Data Privacy Act na you can actually claim damages from them, no? Kasi dahil dyan, posible na if you plan to retire tapos may outstanding loan ka pala, hindi ka kaagad-agad maka-retire, or even if you may be allowed to retire, yung unpaid loan mo, ibabawas nila sa mga ika-claim mo. So, you can claim right to damages on that. Okay? Or dahil ang isang bank company issued a credit card on your behalf tapos sa iba nila ni-release, so that's another example of you can claim right to damages. So these are examples where your information na pinasa mo ay pwedeng magkaroon ng legal implications. And of course, you also have the right to file a complaint, no? Usually kasi ang gusto ng NPC, if it involves any violation of data privacy, pwede kang dumiretso sa kanilang mag-file ng complaint, but there's nothing also preventing you from filing a civil or criminal complaint on top of the complaint filed with the National Privacy Commission. The National Privacy Commission is the lead agency in all things violating the Data Privacy Act. Okay, and then the right to rectify. So you have the right to dispute and have corrected any inaccuracy or error, no? Very common examples nito is yung mga attendance sheets, mga information sheets. So like for example, when you go into service, syempre dali-dali, pinapa-provide ka ng, may pinapa-fill up sa'yo na employer's profile, no? And then later mo na lang na-realize na mali pala yung information na naibigay mo, you may actually ask them to edit that information. Since, as I have said, you are the owner of the data that you provide. So there is nothing preventing anyone from you correcting such information. And then, last but not the least, I think na-mention din ni Ma'am Akmila, yung the right to data portability. Yung pwede mong i-download ng yung information and you may be able to give access to another agency or yung data pinaka-common example na laging sineset in data portability is yung download settings ngayon ng Facebook or ng Twitter, no? You may be able to download yung mga pinakalumang posts mo, mga pinakalumang uh, tweets mo, etc., etc. Before, there was a certain period na kapag lumagpas, nawawala yung tweets mo, no? Pero ngayon, pwede mo na siyang i-download. So, even if these kind of applications are on an international setting, yun yung maibibigay ko sa inyo na example ng right to data portability. So, these are the specific rights na pwedeng ma-violate under the Data Privacy Act, which I think should be given importance by startups such as you, no? Kasi ngayon ang dali-dali magbigay ng information. In fact, the giving of your address itself to Food Panda or Street Buy or Grab is already very alarming. In fact, I'm not comfortable with the kind of storage of data na naiiwan lang doon yung address mo, no? Mas bet ko yung natatanggal siya kahit na paulit-ulit mong ini-enter ang iyong address, at least hindi siya nakastore na gano'n. Kasi we don't know the strength of applications like that, no? Paano kung maging open yun for hack, which is very common nowadays. But at least one thing is for sure, when you give out information, always see to it na nabigyan ka ng privacy policy, meaning para saan yung information na sinostore mo o binibigay mo sa kanila, no? Very important din na you always, kapag tumatawag ka sa mga call centers, no, like for example, you would call Globe, Smart, BPI, BDO, yung mga call agents nila, di ba may part doon na tinatanong nila kung pwede bang i-record ang information, and then you always hear, pakinggan mo palagi anong reason na i-record nila yung information mo, kasi sometimes hindi nakalagay kung bakit. So failure to inform for what reason the information is stored or is recorded, nagkakaroon sila ng avenue doon na gamitin ang information mo for whatever purpose. So you have to be very careful with that. Okay? Another example is isa ding na experience namin, no? For example, in webinars like this, we hire documenters. So dapat meron ding privacy policy ang mga contract, ang mga service agreements with service providers. So yung nag-record, yung nag-video, no, mga videographers, kunwari gagawa ng SDE, dapat may privacy policy na ngayon. Yung photographer in a certain event, hanggang saan ang storage niya, okay? Because being a photographer in a very intimate event, may access ka sa mga personal information nila kahit na hindi nila sinulat yon, just by looking at the pictures alone. So pwede ba na, for example, someone is trying to prove a case or etc., may gusto lang siyang alamin, pwede ba niyang kontakin yung photographer na yun at sabihin na, can I have access to the weddings that you conducted? So when you sign a contract for service providers, kailangan may hangganan ng information na nakuha nila or data or pictures or whatever they were hired to do. Dapat merong nakalagay doon kung para saan ang information na hinihingi, meron sila sa iyo, and up to what, pag na-turn over na ba sa iyo yung information or yung data or yung pictures, for example, hanggang doon na lang ba yun o iso-store pa yun ni photographer or videographer? There was one photographer na I appreciated so much kasi tinanong niya actually, no? Tinanong niya kung, ma'am, may I be allowed to post the pictures in Facebook? You may be the photographer, pero hinire ka to provide that services. So you still have to get the consent of the person who hired you or of the people who hired you for you to be able to create your portfolio online. So these are little things na hindi napapansin ng ating mga businesses or startups such as yours na naiiwasan, that can actually make you liable for the Data Privacy Act, or sometimes if online cybercrime Privacy Prevention Act. At alam nyo ba na ang Safe Spaces Act ngayon, kahit na anong uwing impormasyon online that might harass a person or cause her any form of harassment, pwede din. So tatlo kaagad ang batas na na-violate mo if you're not careful with the information that you have. So yung mga simple lang na, Heva, may number ka ba ni Sure, for example. So, hindi mo agad ibibigay yon. Even if you have that information, that cell phone number is personal actually to Ate Sure. So, dapat kukunin mo muna yung consent ni Ate Sure to be able to transfer his number to another person. No? For purposes of legality, I think hindi pa, there, let's scratch that. For purposes of legality, under the Data Privacy Act of 2012, verbal consent is already a compliance, no? Unless refuted by the person who owns the information. Unless sabihin niya na hindi ko binigay yung consent ko, etc. But verbal consent, substantial compliance na yun. Kumbaga, okay na. Okay? So, what else? Am I missing anything? Rights. Last but not the least, no, to cap it off. One thing that is very important is always, lagi nyo pong, if you're a startup company or a business or whatever kind of, ano bang tawag dyan? Engagement that you have that would need to store information, always put in mind your client's expectation of privacy, no? Lagi nyo pong iisipin na ini-expect ng client ko that I will protect her information to the best of my ability. So, hindi mo basta-basta dapat sinostore yun. And I would really suggest that you would have a disposition system for at least every 3 years, delete ka agad ng information, or every 2 years, delete ka agad ng information, because that would also be a sense of protection for you in case you are faced with a complaint or you are filed a case of violation of the Data Privacy Act, no? Kasi pwede nyo naman po sabihin na we practice the data disposition system every 2 years or 6 months. So there is no way that that information came from us na naipasa sa ibang agencies. So always, the golden rule that I would always try to share with data privacy is always consider your client's expectation of privacy, or you would put them yourself in their shoes na kung ayaw mong makuha ng ibang tao ang impormasyon mo, then that would actually help you in storing their information. So yan lang ang mga basic na makikita ko. With any legal implications, always have your privacy policy. For what reason are you are you storing their information? Number 2, always have the number of your data protection officer on hand, no? Para may makukontak ang mga clients mo. Hindi yung magfa-file na siya ng kaso o magreklamo sa police, etc. At least, on a certain level, nagkausap kayo ng data protection officer, because the DPO is the handler of all information storage and protects all information stored with them. And then always get the consent of your clients, no? Agree or disagree lang naman po yan. Minimum compliance. Everything now can be done with a click of a finger online, thanks to the new normal and technology. And always remember, as a rule of thumb or as a basis of compliance, is your client or is your client expecting or has an expectation of privacy on the kind of services that you give? Because if there is, then dapat hindi lumalabas ang information mo. There is very little, hindi pa masyado maingay ang filing of cases on violation of right to privacy with the Commission on Human Rights, because it's the National Privacy Commission that actually handles it. But it is one of the laws na na-encounter ko na napaka-rights-based, no? Madami siyang ginagarantiya na karapatang pantao, which I think is also one of the reason usually natatap kami or napapasa sa amin ang mga cases on violation of right to privacy. But nevertheless, as long as you are careful with your storage of information, I think you're safe, no? Okay naman po yung handling of information. So I think that would be the part of the Commission on Human Rights with regards to protection of privacy and rights-based approach on privacy in the Data Privacy Act. So kung meron man akong hindi na-touch, I am now open for questions with the group. Thank you.
Thank you, Miss Hiva. Did I pronounce it right, ma'am? Miss Hiva.
Heva, thank you.
Okay. Oh, okay. Again, the virtual floor is now open for questions. Do you have any questions from our incubatees?
I have a question again.
Okay, go ahead, Kit.
Okay, so say I'll just give a scenario lang kay because I believe na there are nuances that I'd like a clarification lang uh, for example
Sure.
we state that we delete the data, but does this entail deleting everything each data na hindi necessarily identifying data. For example, we keep receipts of the customer, right? Because we need transaction records, and in case na may mga dispute, or for instance that customer bought an item and then 6 months later turns out that that item was defective and gusto siya mag-complain, and then if we erase every data, so there would be no way for us to trace back what happened to
Mm-mm.
that transaction. Hence we wish to keep those things in case of disputes. So how would we is there an exception, or should we state that in our privacy statement?
Mm-mm. Actually, ang inyong privacy statement, to the best of your ability, make it as comprehensive as you can, no? Sticking to the example, I think even receipts have lifespan, no? Kahit sa mga BIR hanggang 5 years lang ata ang pwede mong iano doon. But if ang point ko lang sa disposing of personal information is what is personal to your client. But I think a receipt is wala namang pangalan yun, no? Unless of course it was bought via credit card or etc. You look into the documents that you store and you see to it that there is no personal information, but it is within your discretion. For example, kung gusto mo lifetime ang pag-save ng information mo, ang iniiwasan lang natin is ang pagpasa ng information sa ibang tao na hindi rightful. But if you want to be able to keep your information for a certain period of time, like for example, forever, hindi yun bawal. Okay, okay lang yun. But kaya ko kasi sinuggest yung disposition of personal information kasi para protection sa'yo in case that you would be hold liable na ang tao lang na alam kong pinasahan ko ng impormasyon na yan is, for example, ang e-hatid store. So paano malalaman ni ganyan-ganyan? But if you would prefer that your documents be intact, okay lang din yon, no? Okay na okay din yon. But there is no specific rule on how kung gaano katagal mo i-store yung information mo. There is also no specific rule if hindi mo pwede i-store yung information mo. In fact, you would need to store your information. Sa government nga lang na part, any sensitive information or personal information stored by us within the last 5 years, pino-forward namin sa National Archives of the Philippines. No, I'm not really familiar with the private sector, but if yung private na business, I think there's nothing wrong with storing an information beyond, no, mas matagal pa, or kunwari yung warranty ng, di ba usually po yung mga warranty ng may mga like yung foam, no? Did you know that a foam has a warranty of 5 to 6 years? So definitely you would need to keep that information in case na i-avail ng buyer yung warranty na yun. So, okay lang naman siya. Like I said, always set as a ground rule yung expectation of privacy ng iyong client, no? So, sino nga yung nagtanong nun? I hope I answered it
Yes,
correct.
very clear ang ano mo. And in our on our end din for safety measure kasi we have an interface, and a place to view all these records. So what we talked about with the programmers is just to assign parang mga like a number or an ID to each transaction. That way it will become parang anonymous. But if you really have to dig up, for instance, there are in case may mga lawsuits, then we can definitely really
Yes.
get the shovel and go back to the
Yes, yes, oo.
investigations. Okay. But in terms of access ng mga staff or anyone that has view of the yung interface mismo, they won't be we were planning to make it anonymous now once it's an archive already.
Actually, the Data Privacy Act requires that you have your data protection officer. So even if you would want to store information beyond 20 years or 30 years, as long as may access lang talaga nun, isang DPO nyo, then there's really no problem with that. Yung burden nga lang of security lies with your DPO, pero okay lang din talaga yon as long as that information is not accessible by people who do not have authority to access it.
Uh, the DPO has to be an employee or a core member of the organization, or can that be a third party like?
Usually in my experience, it's always part of the organization, and for security purposes parang hindi maganda mag-hire ng DPO outside of your company, no? Like for example sa amin, since I am in charge of activities, so sa akin napupunta ang mga attendance sheets and registration personal information, I am the DPO of CHR10. So for security purposes, no, I find it very uncomfortable kung third party. Pero if there is a specific act that does data storage or data ano, I think that's okay. But you would need to look into the technicalities of that, no, kasi parang mahirap kung third party ang may hawak ng information na kayo dapat ang nagso-store. If that is the case, you would need to put the contact number or the email address of the data protection officer so that the information will be accessible to the data owner in case na gusto niyang ipa-delete ang information. So kasama yun sa privacy policy.
Okay, that's very clear. Thank you very much po, ma'am.
Welcome.
Ma'am, thank you, ma'am. Ma'am, I have a very interesting question, a follow-up to that. Of course, our startups collect and store data. For data acquired from their customers, just to be clear, how long should startups keep this data? Do they have a data retention schedule in place that should be in line with legal and regulatory compliance?
Sabi ko nga po, sinet ko as an example is a government last 5 years, no? But I'm not familiar with the technicalities of how long, but whatever kind of storage of information on how long you may want to store it, I do know na kailangan mo lang yun ilagay sa privacy policy mo. Kami kasi we are governed by the government, so what is provided under the National Archives of the Philippines, yung NAPC circular, ang alam ko sa amin 5 years lang. But considering na private kayo, as I have said, if your services offer a warranty of 10 years, then siguro pwede kang 10 years din ang length of information storage ninyo, no? From what I know there is no specific time or year na nakalagay sa batas kung gaano katagal ang data retention ninyo. Okay?
Okay, thank you, ma'am. Okay, do we have any other questions from our incubatees? Okay, again, then let me remind you na if you have questions, kindly indicate your name and also your startup, of course, for Miss Eva to know. Anyone? Okay. Sige, sige. Since it's time naman then, okay, I will give the last two questions, ma'am, if it's okay. So someone also has sent a private message. I will read it
Mhm.
for you, ma'am. Okay. Okay. In this pandemic, we've resorted entirely to digital platforms, especially when it comes to promotions. What should startups be wary of when they post on social media sites that will not violate data privacy?
Okay. For example, for promotions, no, I think can I stick with that kasi it's something that I'm very familiar with. We've done away with posting pictures of our webinars, no. Tinanggal na namin 'yon. Why? Because I think na-mention din ito ni Ma'am Akmila, no. Siya din po kasi yung nag-enlighten sa amin ng fact na 'yon. Just the mere fact that I'm opening, actually I'm not comfortable with opening the camera. Kaya lang kasi naglalag yung cellphone ko kapag nag-virtual background ako. But again, I for purposes of promotions, number one, you ask the consent, no, kung pwede bang i-open, because opening of a video, uh, binuksan mo masyado yung personal, ang dami na yon na implications na pwedeng ma-access ng isang tao sa personal life ng isang data subject. So, number one, we've done away with posting online yung mga ganito namin, especially pag yung group photo na ino-open, no. Number two, before you start any promotions activity, as I have said, do not immediately record. Inform your data subjects that you are recording it. Okay? And then kung meron kang registrations or online registrations or feedback evaluations that would need or give, ibibigay nila ang kanilang personal information, always see to it that meron kang privacy policy. I've noticed that there are a lot of people um, who post their attendees online, no, yung picture. So, kinuha mo ba yung consent ng attendees mo when you posted that? So, that kailangan palaging may consent. You have to be very wary of it. Even if the Data Privacy Act is a law of 8 years na, medyo konti lang ang may alam nito. So, paano kung may biglang may makaalam nito, no? Especially, guys, if your audience are minors, please do not post their pictures or any kind of information about them without their consent. In fact, without their parents' consent. Okay? So what we did, binablurred na namin yung pictures ng mga bata. And then, in webinars like this, always see to it that your participants put their full name, kasi minsan may mga nakakapasok na I don't know, just for the heck of it or nai-enjoy lang nila. May mga participants na nagjo-join na hindi naman pala talaga, just to get information from other people. So although this has made sessions like this or activities like this more easier, but it has made information gathering more, sobrang vulnerable na, no, kahit yung mga pictures pwede nang kunin. So yun yung mga gusto ko lang i-remind sa inyo with regards to mga ganyan na online activities. Tama po ba yun? Yun ba yung question?
Yes, ma'am, you got it right. Ma'am, in that regard, what are the penalties of violating the data privacy so that we as an enabler and as well as our startups present can understand the gravity of the matter?
Iba-iba kasi yung penalties ng Data Privacy Act, no? For example, the act committed, hindi siya katulad nung data na nung batas na, for example, if you commit rape, etc., 20 years ang ganyan, or kung ganyan, 15 years, etc. It's actually iba-iba siya. Tapos, medyo mahaba siya. It's Chapter 8 of the Data Privacy Act. So, for example, no, just one example lang po. Unauthorized processing of personal information and sensitive personal information. So, pwede kang makulong na 1 to 3 years, and you may be asked to pay a fine of 500,000 to 2 million. Okay? Pero kapag naman daw po second penalty, etc., 3 to 6 years and 500,000 to 4 million. Okay? I-share ko din na in Safe Spaces Act, yung online harassment nila, like for example, kukunin mo yung information ng isang tao, ilalagay mo sa Facebook, no, mga identity theft, etc., etc. The online harassment as well as Data Privacy Act as well as Cybercrime Prevention Act, kung gagawa ka ng listahan ng mga penalties, ang pinakamataas na mga penalties po ay itong mga online crimes. Okay? Millions ang fines or fees of damages, mas mataas ang years of imprisonment. Why is that the case? Kasi explanation sa amin ng NBI or National Bureau of Investigation is the act never stops. If anything is done online, there is no possibility of you ever erasing a trace of that act, no? 'Di ba pag may nilagay kang isang picture, magba-breakdown daw po yan to a many million etc. na pieces which will be scattered all around the globe, and anyone who has the capacity to get that information or retrieve that kind of information online may still be able to retrieve it, which is why if you feel that your safety or your privacy has been violated, you go to the two leading agencies on that can actually do this, the National Bureau of Information, which has a cybercrime prevention unit, as well as the Philippine National Police. So yan ang rason kaya ang taas-taas ng penalty with any crimes done online, because the act never stops. It's just there. Nandyan lang siya sa World Wide Web, which can be retrieved by anyone. So meaning, if may mag-post ng nude photo, if na-delete na, even if it is deleted, the act has already been done, and there's a possibility that someone may be able to retrieve that nude photo again. So ang daming actually penalties ng Data Privacy Act. Please refer to Section 25 of the Data Privacy Act. No, it's a case-to-case basis, depende kung ano yung act na nagawa mo. Like for example, improper disposal. Like I said, always see to it that you have a proper disposal if you have a disposal manner, no? Kasi kung yung information, like for example, a little red flag yung third party ang kukunin mong data protection officer, no? So, hindi siya covered ng business nyo, pero dahil third party siya, he or she may be able to sell that information to other. So that's an example of improper disposal of information. So ano ang penalty po nun? Pwede kang makulong ng 6 months to 2 years, and your fine is 100,000 to 500,000 pesos. So it's always a case-to-case basis. But I guarantee the fine or the penalty is not less. Malaki po pagka online. Okay?
Noted, ma'am. Okay. On to our last question, ma'am. Would a verbal agreement suffice, ma'am, when a customer agrees to post the transaction into the startup's social media?
Yes, as I have said, kung for example mag-interview ka lang, kahit na anong klaseng kuha ng data information, for now verbal consent is sufficient. For now, hindi natin alam kung anong mga bagong rulings, but to this date, for now, verbal consent is actually okay. Okay, so kahit na anong manner of provision of sharing of personal information.
I see. Thank you, ma'am. So that's it for our second session. Again, ma'am, thank you so much, Ms. Eva. We have learned a lot. We will surely take note of those. But before we proceed with the next part, we humbly request the incubatees to please accomplish the online evaluation forms of our Firestarter virtual evaluations 1 to 12. Rest assured, the collection of feedback from you incubatees will solely for the documentation and evaluation purposes of CTO Bytes. For us, of course, to gauge our strengths and weaknesses, especially during our incubation program. Please bear with the length of the evaluation and be honest with the feedback so we will know which areas we have to improve and sustain. So that would be all from me. I will now turn over the virtual floor to our beautiful project leader, Ms. Rhea Hagisay.
Hello, good morning, everyone. So, thank you again to our esteemed guest. So, we have Mamaki and from the Commission on Human Rights. Yun pala ako. And of course, thank you CDO Bytes for another wonderful Firestarter session on a Saturday morning. And finally, to our incubatees for always giving up their time and their attention to attend all our weekly Firestarter sessions. Needless to say, our topic this morning is so timely and relevant. We know that we are still starting up your respective businesses. However, this is not an excuse for you not to know the law with regards to protecting the privacy and information of our customers and clients. Moreover, it was always a good practice that as early as now that your respective businesses and organizations are still small, you already know the protocols on how to go about it so that when your startup will snowball and make it big in the industry, at least you already are protected and you already have standards in place for your protection. Moreover, with the proliferation of software and apps that requires customers' information, it is more vital that you and your respective businesses know how to handle such information. This not only are you pursuing and following the law, but it also adds protection and trust to your respective customers. So more than anything, it is always timely and relevant that customers know how you handle their information. And if you already have this respective standard, more customers will trust you and your startup. So again, daghang salamat to our respective guest speakers. Thank you, CDO Bytes team, and thank you, Incubatees.
Right. Thank you, everyone. Hebs, thank you so much.
Thank you,
Thank you,
ma'am.
ma'am.
Thank you, everyone. Enjoy the rest of the year. See you sa checkup meetings.
Merry
Merry
And happy
Christmas.
holidays.
Christmas! Happy New Year!
Happy New Year.
Bye, everyone.